Good afternoon, ladies and gentlemen. This is Professor Slabbert. It's still about 7 minutes before we start. If there's any questions that you would like to ask, you are welcome. Anyone with any question? Yes, I see Wesley. Your hand is raised. Wesley, can you hear me? You must just unmute yourself and then you can speak to me.
Good afternoon, Professor. Professor, if my calculation is correct, activity number 3
Yes.
is out of 49 marks and not 50.
Oh dear. Let me check quickly.
Sorry if I make a mistake, but I
Okay, so 19, 36. Okay, do you have the questions in front of you?
Professor, yes.
Okay, so question 1 is 6.
Yes, question 1 is 6.
6
Question 2.
and question okay, question 2 is 12. Is that correct?
That's 18. That's correct.
Okay, that's 18. Sorry, plus 18. Okay, and then question 4 is 8.
That's right. So that is 16. That is 24.
Question 5 is 5.
Question 4 is 5. That is now, can I say 29? 6, 18.
Yes,
18,
yes,
6, 29.
yes. And then question 5 is 5.
29 is 33.
33. Question 6 is 4.
Is question 6 4? Okay, I make it 3 years.
Okay, is it indicated on the question as 4?
Professor, can we only check it? 6, 12,
Okay.
8, 5, 4, 4, and 11.
Yes.
Okay, sorry, Professor, it's my mistake then. Okay.
Don't worry. I'll check again. And if you are right, because we're doing this now fast, you will all get that 1 mark.
Only for yes, if there's 1 mark short, you can give it to us, Professor.
I will with love give it to you. Okay. Anyone else with a problem? or a question or a comment. Okay, just while we wait for 5 o'clock, just remember to switch off your cameras and mute your microphones. It's just to save data for people who is using data. Okay, it is now 5 o'clock. Let's just see. Can you see my screen?
Yes, Prof.
We can.
Okay. Okay. Thank you so much and welcome to this second webinar. I apologize from the very start that I'm going to talk a lot tonight. So, but I hope you find it informative. Please, let's just do the same as we did with the first one. Let me finish with the lecture and then afterwards we can have a discussion and I'll answer questions. So while I go through the work, then you can make notes and we can discuss it afterwards. Okay, so you know me. I am Professor Magda Slabbert, a professor at UNISA, and I do the webinars, but your real facilitator is Bonnie Venter, and I think you have met her over the internet. Okay, so you are just one group. Remember that for all administrative matters, you must contact Grace. We cannot help you with that. And then just to recap that previously, the previous webinar was on the Constitution and then a brief introduction to the law of contract and the law of delict. And I'm sure you got the slides. The same will be for tonight's lecture. You will once again get the slides. Unfortunately, you're not allowed to get a recording, but that's because LEAD have decided that. But I will make the slides available. So you don't have to make notes while I talk, as you will get the slides at the end of the lecture. So just a few general matters to get us going. Remember to keep an eye on your schedule. And because Bonnie is once a week online, she's not online like I do now, a webinar where you can speak to her, but you can post questions and she will answer you. And if she doesn't know, then she will ask me and we will find the answer. And then I think you've also seen that she has uploaded some extra material that we thought might be of interest to you. Remember those extra material that we give, and even the webinars that I give is not relevant. It's not going to be tested, but it will help you to understand the work for your test one. Test one is multiple choice, and you do it whenever you feel you are ready. But everything extra that we give you is for interest only, and it is just to broaden your horizons to see what medical law is all about. Then I just emphasize, and I think you've realized by now, you have to do the activities as they are posted, otherwise you might run out of time. The activities are not difficult, yet it involves a lot of reading. So you will need to plan your time, otherwise you can fall behind and then it is very difficult to catch up. If something bad happened, for example, you are ill or your law firm has a very important case that you have to attend to, etc., at least a valid reason, then you can contact me or Bonnie, and we will see whether we can make a plan. We feel that you've paid a lot for this module. We want all of you to pass. So we don't want you to give up, rather ask us for help, and then we will look at the merits of each case and we will assist where possible. Okay, then, as I've said last time, you are allowed to speak to each other on the forum, but at the end of the day, you have to do your own work. And as I've said, never give up. Just to recap, the portfolios are 80% of your final mark. There are 2 portfolios. The first portfolio is activity 1, activity 2, and activity 3. And then you look on your schedule and you will have to hand it in as one PDF document. And please remember to have a title page so that we at least know whose work it is. And then, but in the meantime, you carry on with activity 4, 5, and 6. That will be portfolio 2. All 6 marks together will be reworked to a mark out of 80, and then plus your 20% for test 1, and that will be your final mark. As I've said last time, the questions are broader than the study guide. I think you've realized that, and we expect a lot of extra reading. So I just want to make a comment. It is a mistake that I made. In activity 3, question 2, which counts 6 marks. It was a problem between me and Bonnie. But anyway, question 2 is on what did the parties agree? But I want you to add there, not just on what did the parties agree, but also on what did the physicians agree or disagree. And you will see that will make up the full marks. I will also look at the marks allocation, whether we haven't made a mistake or not. So just check question 2 of activity 3. The question reads on what did the parties agree, but I would like you to also add on what did the physicians agree. Okay, so and today's part is the most important. And there, the yellow that I've highlighted is just once again to emphasize that they do not just pay out pain and suffering. You have to prove damages. You will remember from last time. And there's just the case which you can go and read on your own. So those are sort of the background. So before I start with today's lecture, which is basically based on medical negligence, I want to highlight a few interesting things, because this is an introduction to medical law. And as I've said, although our emphasis is on medical negligence, medical law as such is a little bit wider. The first case that is there on your slide, ES versus AC. That is a very interesting case, and I think the full citation will come later. Otherwise, if you want it, I will give it to you. It is a Namibian case. It is extremely, extremely interesting because it concerns the balancing of human rights. And you will find this coming up more and more in medical law or medical or healthcare situations. What happened in that case? It was a 38-year-old woman. She had already 2 children, and then she became pregnant again. But she and her husband were devoted Jehovah's Witnesses. So before she went in for the cesarean section of the 3rd child, she gave a document to her husband that her husband must take decisions for her of all medical issues if she is unable to do it, a sort of advance directive. And as fate was, she went for a cesarean section, and then she had to undergo an emergency hysterectomy. She needed blood desperately. But remember that Jehovah's Witnesses do not allow blood transfusions. They ignored her husband, and her brother went to court. He was from a different religion, and he asked the court for a declaration that his sister should get a blood transfusion, otherwise she will die. And it is not in the interest of the two minor children plus the newborn baby to grow up without a mother. But fortunately, the woman did not get a blood transfusion. She could then say that her husband has full capacity to act on her behalf, and it was going to the court and back, and going to the court and going back. Fortunately, she survived this whole issue without getting any blood transfusion. So she went to the highest court in Namibia to get clarity, so that if something like that should happen again, then there is clarity on how the people should react. It was a full bench of the Supreme Court of Namibia, 3 judges, and one judge was even Judge O'Regan, that used to be a justice in the Constitutional Court. So the 3 judges, they gave judgment. So they had to weigh up the religious beliefs of the woman and her autonomy to make decisions versus the best interest of the children. The majority, in other words, the standing judgment at the end of the day, was Judge Shavute and O'Regan, and they said that the woman's autonomy trumps the rights of the children, or the best interest of the children. So the other judge gave a minority judgment in which he argued that her life should have been spared if circumstances were different, because the interest of the children weighs much heavier. So the significance of this case is that you must remember when you go to the Constitutional Court in South Africa, you must and you can invoke foreign law. So this case stated that the autonomy of the individual is the most important. So whatever this women have decided, that is what should be honored, and not the best interest of the children. So it's a very interesting case to read the balancing of different human rights. You've got on the one hand the woman and her right to self-determination, her religious rights, her rights to her own culture, etc. And then you have the best interests of the children. So that is just for interest's sake. But now I want to connect that to a case scenario in one of the books that I've highlighted, which will be interesting. And this is the book of Kimantri Moodley, Medical Ethics, Law and Human Rights. So I want you just to think, if you, for example, are confronted with such a scenario, what do you think should happen? So there was this girl, she was diagnosed with bone cancer at 13, and her leg was amputated. She had radiation, she had chemotherapy, but she survived. And at 27, they said to her she is now in remission. So she got married and she became pregnant. But while she was 26 weeks pregnant, and it is in pregnancy, it is quite important to determine the stage of gestation, because in South Africa, the Birth and Death Registration Act say that at 26 a fetus is viable. So, okay, she was in her 26th week of pregnancy, and then they discovered that there is an inoperable tumor in her right lung. And they discovered that she's going to die. So they put her on a ventilator. And now the question is, should they give birth to the baby via cesarean section? And they had various doctors, of course, specialists. Some say they must bring the baby into life because he or she is viable. So others said that the test they have done, the baby will not be completely normal. Others said it is too dangerous. If they give her a cesarean section, the woman is going to die. Now, this is difficult. Say, for instance, you are the legal advisor of a hospital and they come to you, and now what should the decision be? On the other hand, that is now what all the experts and the medical people say. But you also, on the other hand, have the husband and the mother of this woman. And they said that the cesarean should not be done. And if it is going that way, then the woman and the baby should die. But eventually, after hearing everything, the hospital decided to do the cesarean and to see whether they can save the child. Unfortunately, the baby died 2 hours after the delivery, and the woman died. And on the course of death, it was stated that the cesarean section was a contributory factor in her death. The reason I'm telling you this is to indicate to you that medical law is not always clear-cut negligence and we claim 20 million rand. Sometimes there are extremely difficult decisions to make, extremely ethical, and there's no specific right way or wrong way. And what you must also remember is that when the next of kin are asked, in other words, the husband and the mother, they are then seen as surrogate decision makers. But they are not supposed to express their personal wish. They are supposed to say what they think the patient should have wanted. And that is sometimes very difficult. If we just think back now to the Namibian case, the woman for 20 years was a devoted Jehovah's Witness, yet her brother was from a different faith. So he wanted to follow what he thought is in her best interest. But remember, when family members, husbands, wives, or parents are asked, they should not give their view. They should help and give a view that they think the patient should have wanted. So it is very difficult. And if they don't know, then they must think, because they know the person, what kind of person she was, and then what she would have wanted. Okay, that is just for interest's sake. Then the next case that I want to highlight is quite a new case. It was handed down in 2021. So there, I want just briefly to tell you about the 3 claims that you can bring where it concerns pregnancy. The first claim is wrongful pregnancy or wrongful conception. That is a claim that you bring to court because you had a sterilization, either the husband or the wife, and then all of a sudden she's pregnant again. In other words, the sterilization was not successful. In that instance, a normal baby is born. But they didn't want the baby because possibly they couldn't afford the baby. They took a decision to be sterilized, and now there's a baby. If they can prove that the gynecologist or obstetrician was negligent during the sterilization, then they can claim on the basis of wrongful pregnancy, and they can claim the upbringing cost of that child, which should not have been there, but the child is healthy and normal. Then we have the wrongful birth claims. These claims are when the woman goes to a gynecologist, obstetrician, and asks specifically that they do tests to determine whether the baby is normal. You will find this very often in older women who wants to know that the child is not suffering from Down syndrome, especially when the woman is very late 30s, early 40s. Then they specifically ask that tests should be done to check for Down syndrome. If the gynecologist then misses it, in other words, he misses the fact that the child has an abnormality. So the child has either Down syndrome or spina bifida or something else. And the baby is then born and the baby is then not normal. Then the parents will go to court and they will say that this was a wrongful birth. If the gynecologist has given them the correct facts, the woman would have opted for an illegal abortion because they don't want an abnormal child because of the negligence of the specialist. Now a disabled child is born. The gynecologist was negligent. The result is an abnormal child. Then they will claim wrongful birth. It is the parents claiming and a disabled child is born. Then they will claim the care cost of that child. In other words, all the therapies that that child will need, everything. It will be a huge claim. That and wrongful pregnancy was accepted in our legal system. It is part of the common law and it's accepted, and we've got many cases on those two topics. But then the other one, wrongful life, did not exist in our legal system. Wrongful life is when the disabled child say, I should never have been born. In other words, it's a disabled child being born, but it is not the parents that institute the action. It is the child. The parents just assist the child. Now, that was contra bonis mores in our legal system until the Constitutional Court case of H versus the Fetal Assessment Clinic. There, the Constitutional Court said that it is now allowed in our legal system. In other words, they have developed the common law that you can now approach a high court on a wrongful life claim, and then depending on the facts, whether it will be allowed or not. So just take note of those three, because that will come up a lot maybe during your practice, or if you go further in medical law. Things tend to go wrong in gynecology. Now, if you read this NC and Another versus Engelbrecht, they once again address those things. The third one, S and Another versus Life Healthcare Group, interesting, private sector. This case is interesting if you want to read it to see how the court argues about when does a doctor-patient relationship start. Usually, in normal circumstances, you will feel ill, you will make an appointment, you will go to the doctor. The moment you meet the doctor, then there is a contract and there's a doctor-patient relationship. That is clear and no problem. But what happened in this case of Life Healthcare, the woman was going to give birth. Her gynecologist could not be there on the day that she was expected to give birth. So he knew she might not deliver, and he will not be there. So he asked a colleague to stand in on his behalf. Doctors do that. So Dr. Suleiman was the stand-in doctor. So the woman goes to hospital and the delivering process starts. And the nurses knew that her doctor is not available on that day. So they called the stand-in Dr. Suleiman. And they explained all her vitals, etc. And he gave some instructions over the phone. They called him again, and he again gave instructions, and eventually he went to the hospital and the baby was delivered, and unfortunately the baby suffered damages. But the question to ask there is, when did the doctor and patient relationship between Dr. Suleiman and the patient started? Was it the first time that he was called, or was it when he was asked to stand in, or was it when he eventually physically went to the woman and assisted with the delivery? So it's quite an interesting case to read, because it's the doctor and the hospital at the end of the day that were accused of negligence. So interesting if you want to see how the court argued when the relationship started or not. The next one, M and Others versus Wim Kreino, that you can only, I'm not going to elaborate on that, but that concerns contingency agreements. And it is interesting to read it to see how the court deals with contingency agreements, because the majority, if not all, medical negligence claims, even road accident fund claims, go on contingency. In other words, the attorney will just get paid if they are successful. But there's a lot of issues concerning contingency agreements. So if you need more guidance, you can go to that case. The Boyce case is not a Supreme Court of Appeal case, so it is not that important. But why I've listed it there is, should you want to see what happens if a case has been started in court and then the child dies. So this was the parents, the mother and the father of this child. The child was already 10 years old. The case was still dragging, and then the child died. While the merits was finalized and the MEC was 100% liable for everything that this child has suffered, but then the child died before the end of the case. So the quantum had to be adapted, because of course you cannot now claim future medical costs because the boy is already dead. So that is just interesting to see how the court dealt with the quantum when the person who is the person that must get the damages dies during the court case. And then remember once again that please go and read the South African Law Reform Commission, those documents that they have there. There's two sort of newer projects, Project 125 on prescription and Project 142 on legal fees. And then I also want to, if you're really interested in this field, to regularly go and Google medical brief, because there are very interesting developments there, which we do not address in this this module or this teaching that we give you, but it might be of interest. For example, now, a few weeks ago, there was this case against MediHelp, the medical scheme that didn't want to pay for the little boy who needed medicine urgently. They know that this little boy will eventually die and he will not grow old, but he will live another 3-4 years. But if he get the medicine, his quality of life will be better in the years that he has left. And then Mediclinic said they're not willing to pay the medicine extremely expensive, and they are willing to pay palliative care. Now, just imagine if you are the mother of the little boy and you must now sit back and watch the little boy die, but you know there are medicine that can help him, but your medical aid is not willing to fund it. So they went to court and the court gave judgment that MediHelp must supply the medicine and they must fund it. So these are developments, interesting developments. There's also a development if you go to either Medical Brief or the Road Accident Fund's website. The Road Accident Fund has now issued a directive saying to medical aid schemes that if a person is in a collision, in a car crash, and they end up in hospital, but they have a medical aid, and the medical aid then pay all the PMBs, all the prescribed medical benefits, then the RAF will not refund them. Now, this is a point of contention because all of us pay a road accident fund levy when we put in petrol, and now they expect the medical aid to cover the medical costs, whereas basically the road accident fund, of course, you can't get paid twice. So how it works, if you have a medical aid and you are in an accident, you will go to hospital, your medical aid will pay for everything, you will claim it from the road accident fund, and then it goes back to the medical aid. But now the Road Accident Fund, for some or other reason, said they're not going to do it that way anymore, but Discovery is taking the Road Accident Fund to court, so we will know one of these days what happened in court. So these are general interesting things, all part of medical law. Okay, let's come back to your actual work. So a contract or delict is part of our common law. What is the common law? The common law is the law that have been inherited through time. In other words, it started with the Romans, with Justinian and his 12 tables. Then the Romans conquered Netherlands. Then we have Roman Dutch law. And then Jan van Riebeeck came to South Africa and brought that legal system. And the British settlers came and the indigenous people were here, and all of that became common law. In other words, there's no specific legislation concerning that. So our South African common law comprises of all law of non-statutory origin, meaning there is no specific written law for that. And then an obligation gives rise to the right of one party to claim a performance fund from another party who has a duty. So the main source of the common law of obligations are the law of contract and the law of delict. I'm just giving this as a little bit of background for those of you who are not legally trained. So when you institute action against either a hospital or doctor or the MEC of a province, you will do it on the basis of either a contract or a delict or both. Whenever you go and see a doctor, there's immediately a contract. A contract need not be in writing, unless a specific legislation requires you to put it in writing. So for the doctor-patient relationship to come into being, to form a contract, it is not necessary to be in writing. It's usually orally. where you go and see the doctor, you explain your symptoms and you allow the doctor to look at you and then make a diagnosis. All of that is then a contract between a doctor and a patient. When you go to hospital, of course, it's more formal. There you will fill in forms. It will be more of a contract than just you and the doctor. A deluct, sorry, I'm just drinking water. A deluct falls in the realm of private law, and that is when a person did you wrong. A deluct is the act of a person that in a wrongful, inculpable way caused harm to another. Now, because of the common law under deluct, all medical practitioners are required to exercise reasonable skill and care when they look after patients. Of course, that can also be drawn through to the Hippocratic Oath, the duty that doctors have, that they must act in the interest of the patient, beneficent, not to do any harm. So that is the background. As I've said, I've highlighted it last time as well. You can sue on the basis of a contract or deluct or both. Mostly in what I see when I read all these cases nowadays, it is mainly on the basis of a deluct. Why? Because if you claim on a contract, you can only claim patrimonial loss, proven damages you can claim. But under a deluct, you can claim non-patrimonial damages, and that is for pain and suffering. So if you, for example, you became pregnant after a failed sterilization, and you go to court on the basis of a contract, your argument will be there was a contract between you and the specialist that you will be sterilized. He didn't do it. You suffer damages. You have a child. You must look after the child. The damages will then be the upbringing cost of that child. But you as the woman cannot claim pain and suffering for the delivery or for the 9 months of being pregnant because you claimed on the basis of a contract. If you claimed on the basis of a deluct, then you can try and say that it was uncomfortable for the 9 months and the delivery was painful, etc. Okay, so what are the requirements to be successful with a claim based on a deluct? And remember, I said that before you can be successful with a medical negligence claim, all those requirements must be proved. In other words, there must be an act, a human should have acted. The act should have been wrongful. Then there must be causation between the act, what the person did, and what the outcome is. Fault is then negligence, and I don't think any doctor will have intention. And then you must be able to prove the damages. Now, it always, when you hear the horrific stories that people tell you what happened in hospital, what did the doctor do, then your mind must go into this action of trying to comply with these requirements. And the most difficult one to prove is usually causation. Because wrongfulness just depends on the boni mores of the society, whether they expect a person to be liable for the damages he caused. But causation is the most difficult. Did that what the doctor do at the have the end result? And then, of course, the damages. But we'll go on causation. Just remember that. Now, what is the test for medical negligence? I've given it very shortly there. If you go to your official study material, you will see that it's a little bit more expanded, but this in a nutshell. And this must never ever leave your head. You must know this off by heart. If I walk past you in Menlyn and I ask you, what is the test for medical negligence? You must know this. This is the test. This is the bottom line. This is what must be proved. How would a reasonable, competent practitioner, specialist or GP in that branch of medicine have acted in a similar situation? Remember at the very beginning when I started the webinars, I said that every bad outcome is not necessarily negligence. Sorry, I'm drinking water. For example, when you do a hysterectomy, you can easily perforate a vein and there can be lots of blood. But the question is now, what does the doctor do if that happens? In other words, what would a reasonable doctor in that same circumstances, what would he have done? And you can only prove this if you get an expert witness. You need an expert in that specific field where things went wrong to come and say he did or she did not act like a reasonable person. Remember, people, doctors are not saints or angels. They are human beings. They get tired, they make mistakes. It is how they handle the mistake they made and what is the end result that will determine. A reasonable, competent practitioner, what will they do? And if you can prove that they did not act like a reasonable, competent practitioner in that branch of medicine, in a similar situation, then you have proven medical negligence. And that is why I argue that we need special medical negligence courts, because you need to know this. This is not just an ordinary way of proving a defect. It is a different test. It is a different test that we apply for medical negligence. As I say, how do you prove it? You can never be successful with a medical negligence claim unless you have expert witnesses or an expert witness, depending on the circumstances. And that is why I once again say that book of Lawrenson and what is the... Anyway, you know the one that I referred, expert witnessing in medical negligence cases. That book is indispensable because it tells you how to negotiate with an expert and be careful for hired guns. There are medical experts there that will say everything that you want them to say and will win your case for you, but the court will not trust the expert. Remember, it is at the end of the day a juridical question. The expert is only there to assist the court because the judge is not knowledgeable in medicine. But at the end of the day, it's a legal question. So where do you find an expert? You now have a case on your table. You now need a expert witness. It is always good to think about universities. For example, get the professor in gynecology or the professor in urology, so that they then come and testify what would be expected of an oncologist or a gynecologist in certain circumstances. They will look at the facts of the case and they must then give an expert opinion whether they think there was negligence or not. Just be careful. If you go to universities and it is old professors, and sometimes the defendant can then raise or make the comment and ask the professor, yes, professor, you are now the expert, but when last did you operate? When last did you do a delivery of a baby? When last did you treat a cancer patient? So be a little bit careful for that the expert you get is not so old that he or she is out of touch with what is going on nowadays in hospitals. But universities a good start, and professors may also be able to refer you maybe to people that they think can be good expert witnesses. And then you can go to the website of SAMLA. It stands for the South African Medical Legal Association. And on their website is a list of experts, and they can also help you. Otherwise, you just speak to your colleagues and you find expert witnesses, or you read cases and you will see the names coming up again and again and again. Okay, now expert witnessing. What will the court? Remember now, the court is not medically trained. So you have the team for the defendant with their experts, and you've got the team for the plaintiff with their experts. And the judge, whether it be one, whether it be three, they must now listen to these opinions. And remember, a medical expert is allowed to give an opinion. A factual witness cannot give an opinion, but an expert witness in medical negligence cases, the court will probably in all situations ask them, in your opinion, do you think the doctor was negligent or not? And then they will listen and to the explanation. And there's nothing that makes judges more furious is when they find out or they can see that this expert witness is a hired gun. In other words, the expert is not willing to concede certain medical facts, or the witness is arrogant. But the bottom line, you will find in the case of Michael versus Linksfield Park Clinic, there the court said the witness that they prefer is the one with logical reasoning. So logical reasoning, in other words, the witness that will come and explain in their view what happened on that day in the operating room, and everything follows logically, and they are willing to concede certain things. And there I would like you to read, if you've got time. As I said last time, do not watch Netflix on Saturdays or Sundays. Read these cases because it is so interesting. The case of Oppelt, because there were different views of experts in detail. And as I've said previously, I go with the one the court did not go with. So I don't go with the judgment that the court gave. The court accepted the one team of experts. I found them just by reading the court case. So I'm not trying to criticize the judges because I just read the judgment. But I would have gone with the other experts. I found the experts whom they accepted a little bit arrogant, but that is for you to decide. Okay, there's the book that I was looking for, Van der Heever and Lawrenson, Expert Evidence in Clinical Negligence. Irrespectable. You must have this book if you are going to practice as an attorney in medical negligence cases, because that books help you every step of the way. There's examples. There's a whole chapter on what is expected of an expert. Because remember, doctors do not know the court. They don't know what is expected of them. If it's the first time they're going to court, they will be scared because they do not understand the legal system as such. But that book will help you step by step how to prep your expert for a medical negligence case. Okay, how do you prove a medical negligence case? On a balance of probabilities. And this is a lighter a duty to prove. Remember, in a criminal case, you have to prove it beyond reasonable doubt. But in medical negligence, it's on a balance of probabilities. As long as you have complied with all the elements of a delict, there was negligence, someone suffered damages, the damages suffered is causally linked to the negligent conduct. If you can prove all that, you will most probably prove your case. As I've said, causality is the most important part to prove. You get legal causality and factual causality. Factual causality is just the but-for test. If you think but for the negligence of the gynecologist, abnormal baby would not have been born. That is the factual causation. The gynecologist missed all the signs. He didn't do the test thoroughly for Down syndrome, and now a Down syndrome baby is born. Factual causation. But for his negligence, the child would not have been born. Legal causation is a little bit more difficult, but it follows that the doctors need to be punished. It calls for punishment because the gynecologist, who is an expert in determining abnormalities in fetuses, should be able, and therefore he should be punished, if I can call it like that. But the only way that you are going to master causality in detail, and this is actually becoming a little bit of a problem. If you go and you read all the court cases, every case you can find in any high court in one of the 9 provinces on cerebral palsy, you will see the varying judgments. So this judge will say, yes, they have proved the negligence of the hospital or the doctor. The other one will say, no, there's no causality. The others will say, it is difficult. Did it happen in utero? Did it happen during birth? Did it happen after birth? Causation in all those cases, very difficult. Okay, but what are the factors that influence medical negligence? And there you have that Latin, imperitiae culpae ad numeratur. That means where a GP act as a specialist. In other words, let's say it's a GP in Randfontein, and he thinks he's good enough to do breast enlargements, and it goes terribly wrong. The one breast is under the armpit. It is just terrible. Then the test, you will not test this doctor as a GP. He will be tested against the specialist, against the test for a plastic surgeon. Would a plastic surgeon who's doing breast enlargements have put the breast under the armpit? No, he wouldn't. In other words, the GP acting as the specialist will then be tested against the measure of the specialist. An example there is Frick versus the Scores case. There, the lady has to undergo a gastronomy or a gastric something, and this doctor was just a GP, although she did all the courses to be a surgeon. She was not yet registered as a surgeon, and things went horribly wrong. And the poor woman had to undergo a series of operations to correct everything that went wrong. And then in that court, they said that because she acted as a surgeon, she is tested against how a reasonable surgeon would have acted, and a reasonable surgeon would not have done what that doctor did. And of course, she was found negligent. Then there is something in medical law, which is very interesting, and that is called the locality rule. Sorry, I'm just drinking water. The locality rules say that where you practice has an influence on the outcome. For example, if you do an operation in Groote Schuur in Cape Town, does the same rules apply than in the local hospital in Bella Bella? Or can I expect the same from a private hospital in South Downs or in Midrand or in Rosebank? Can I expect the same standard of care than Ga-Rankuwa Hospital? That is the locality rule, is whether there should be a difference or whether there is a difference. And it, in other words, goes to a geographical area. And there I've just added an article written by Professor Carstens, who is the guru of medical law. He's at the University of Pretoria. He wrote an article on it. But it basically means, should it be taken in account or not? So if you go back to the Van Wyk versus Lewis case, the 1924 case, you will find two different views on the locality rule. You have one group of people that say no, all health practitioners go through the same training and we expect the same diligence from all of them. And then you have another group that say, no, you cannot, because logistically it is more difficult in Bella Bella because there might not be all the equipment. At this stage, there is still no clarity in our legal system. It hasn't been challenged as far as I know. So it is still those two views. It will be nice if someone challenge it again and see what the outcome is. But in essence, then the locality rule is just to ask whether different rules apply according to the geographical area where you practice. And people sometimes think that medical negligence only happens in public hospitals because they are understaffed, because all the equipment is not always there. It is not necessarily always the case or so per se. Things also go wrong in private practice and private hospitals. The only difference is that in the majority of cases, the negligence that happens in private hospitals are settled out of court because the private hospital doesn't want their name in the media. So therefore, they give the job to one or other law firm, and that law firm will then negotiate with the parties and find a settlement so that it doesn't end up in court or in the media. Okay, then just note that when there is medical negligence or alleged medical negligence, that is it. You do not speak of gross negligence in medical negligence cases. If there's negligence, there's negligence. Whether it is scissors left in the abdomen of a woman's body, whether it is amputating the wrong leg, whether it is slipping and the patient becomes blind, all of that once you have proven the requirements of a delict, you have proven specifically causation, then that is negligence. It's not necessarily gross negligence. Gross negligence might have a bearing on the sentence or the punishment, but mostly in disciplinary hearings, not necessarily in courts, because once you've proven medical negligence, then the responsible party will be responsible for the damages, irrespective whether it was gross negligence or not. So it might have a minor bearing on the sentence or punishment, but in the third webinar, when we speak about disciplinary hearings, then it might have an influence there. Contributory negligence, that is when the defendant come and say, okay, we agree there might have been negligence, but the patient also contributed to the outcome, to the damages. For example, in the Dube case, Dube was not a highly skilled person, just an ordinary worker, and his arm was put in plaster, and they then told him that if he feels it's too stiff or something's not right, he must come back. But because he knows absolutely nothing about medicine, he just thought, okay, his arm is not lacquer, but he didn't go back because he thought that is normal. It should have been like that. And then eventually he couldn't stand it anymore, went back, and they had to take off the plaster and amputate the arm. And then the argument was, but the patient should have gone back to hospital sooner. So he contributed to the negligence, and the court said no. They did not accept it because they should have given him specific instructions or specific direction how he should know he should come back. Errors of judgment, remember, that is also not necessarily negligence. You still do the test. Would the ordinary, reasonable doctor in the same position would have made an error of judgment? As I say again, doctors or health practitioners, they are just human beings. And sometimes they can make a mistake. They can make a mistake. And that is not per se negligence. The test will be, would the ordinary, reasonable doctor with the same skill, the same training, in the same circumstances, have made an error of judgment? Then it is not necessarily negligence. Okay, so I have focused on the requirements of a delict because most medical negligence cases go to court on the basis of a delict. But there are some criminal cases. And if you go to Medical Brief or even News 24, you will see that I think last week a surgeon was arrested in KZN on criminal charges because the patient died. So, and previously, a few months or even a year ago, people were also arrested, if I remember correctly, at Milpark, and the one eventually died. And the other one will still be prosecuted. So it is something that is happening. Whether that is right or wrong is each one of you must decide for yourself. And that is why you must also go to the Law Reform Commission, because they are arguing that doctors should never be criminally liable. I disagree. I feel doctors criminally liable. I even feel that nurses could be held criminally liable because maybe then their bad behavior, in inverted commas, will stop. But the one example that I have there, and if I'm correct, it's also your second question in your activities. What happened in the state versus Van der Walt, and it happened in Mpumalanga. Now, this is terrible, but I think one can only judge the case if you read the case of the High Court. The case started in the regional court. The Dr. Van der Walt didn't testify. He didn't have witnesses. So the regional court could only fall back on the testimony of the witness that the state had. Okay, and then, as you know, you did it for your activities. He was found guilty. Then he was refused to appeal to the Supreme Court of Appeal, but he appealed to the High Court. And in the High Court case, all the facts become clear. Now, what I've taught you tonight, if you read that case, constantly keep in the back of your head, did he act like a reasonable gynecologist would have acted in the similar circumstances? That is the test. In other words, he knew This woman was giving birth. She insisted on giving birth naturally. Therefore, she was too small, and therefore there was a tear. He should have foreseen that. He should have approached it differently and allow her to give birth naturally, because it's her autonomy, it is her right to self-determination. But then he should have in his head made plans that if she started bleeding, what would he have done? What would a reasonable gynecologist have done? Not what he did. And that is where I feel he failed the test. When he was notified that she did not stop bleeding, he should have gone back immediately. He should have taken her to a theater where there are good lights, and he should have stitched her up better than doing it in the delivery ward with, if I'm correct, a torchlight or whatever. But the mother testified that it looked terrible and there was a tear from her vagina to her anus. Unfortunately, the Constitutional Court did not entertain the merits at all, and then, of course, they gave the judgment that it was not a fair trial. But I want you to think about this case and think, is this a route one should go in the health profession, the criminal route, or not? But the test stays the same. Did he act like the reasonable doctor with the care and skill that he possessed, and in those circumstances? Okay, then there's also the S versus Kramer case. You can see also a criminal case. It was against an anesthetist. I'll come back to that one just now. Okay, remember just that the burden of proof in these cases is different than when it's a delict. If you have to prove the requirements of a delict, you will do it on a balance of probabilities. But if you go the criminal law case, then it has to be proven beyond reasonable doubt. Now, just a side note. Always remember that when you go to an act, to check an act, never forget that an act, for example, the National Health Act, is only the skeleton. The flesh are all the regulations in terms of the act. So what happened in this case? It's a criminal case, S versus Frederickson, and it happened in the Free State High Court. So this guy, I can't remember, he was from Sweden or Denmark or somewhere, but he was bad. He had a firearm with no license, etc., etc. But he took Lesotho women into his house. He then offered them a certain price and gave them alcohol, and then he circumcised them. So he cut out the clitorises and then put it nicely labeled and named into his freezer. So he was eventually caught out because he had human tissue in his possession, and you are not allowed to have human tissue in your possession. But they went to court on the basis of the National Health Act, which replaced the Human Tissue Act. And then the judge and the two teams of advocates, not one of them realized that there are regulations in terms of that act. The act itself say that you are not allowed to have human tissue in your possession, and if you're not a doctor, you cannot take human tissue from a human being, and it should be done in a hospital. So of course Frederickson was not a doctor. He didn't do it in a hospital, and he had it in his possession. But then the judge said that they must drop the charges against Frederickson, all of those concerning human tissue, because the act, the National Health Act, does not state a penalty for transgressions of those articles in the act. Those of you who are lawyers, you will remember your criminal law 1 Nulla puna sine lege. You cannot punish someone if the law doesn't have a penalty clause. And the judge said, but the National Health Act does not have a penalty clause, and therefore they must drop the charges of this Frederickson having human tissue in his freezer, and it must go to the legislature to change the National Health Act. And it is, according to my view, a big mistake, because the regulations in terms of Chapter 8, which concerns human tissue, specifically say that what is the punishment or what is the penalty. So the only reason I tell you about this case is it is quite interesting, but never ever in your arguments, if it is a medical matter, never ever forget that there are always regulations in terms of an act. Let's come back to medical negligence. So we're back now to delict, and we're now addressing causation. As I said, causation, in order to prove that, factual causation. The conduct caused the damage. We call that the but-for test. But for the negligence, the damage would not have happened. Legal causation is the act and the harm close enough for legal liability? But if you want to see exactly how the courts argued this causation, then you can go and read the case of Lee versus Minister of Correctional Services. Mr. Lee had to go to prison and then contracted TB. So, but it's a difficult case, but it's an excellent case if you want to see how the courts deal with causation. You can also, S and another versus Life Healthcare, that's the Suleiman case that I spoke about. Also, if you want to see how the courts work with causation, that is also a good case to go and read. Okay, I've said that the plaintiff must prove on a balance of probabilities. In a criminal case, it must be proven beyond reasonable doubt. Then there is something that you will find in Van Wyk versus Lewis, the 1924 case. Res ipsa loquitur. And in that case, it is important. Res ipsa loquitur means the facts speak for itself. But it is not accepted in South African medical law per se, unless it's specifically proven. For example, there is this person and abdominal pains and eventually goes to the doctor. She had an operation and the doctor said, but you had an operation, things doesn't seem fine. Let's back to the operating theater, opens her up and find gauze or scissors or tweezers or whatever in the abdomen. Now, all of us will say, that is negligence. That is negligence. A doctor should not leave a scissor or tweezers or a swab in a person's body. That does not stand in South African medical law per se. In other words, you cannot take a case to court and say to the judges, but my lord, this is obvious that this doctor was negligent because there were scissors in her abdomen. You cannot do that. You have to prove what was the circumstances. Was the person going to die within seconds and they had to stitch her up? And there was no time to check all the equipment or whatever. It is not automatically. The judge cannot then say, yes, I hear you, advocate so-and-so, let's punish this doctor. The facts does not speak for itself unless it is so glaring that you cannot draw any other conclusion. And there I refer you to N versus MEC for Health. This poor lady gave birth. It was a cesarean section, and during the cesarean section, they cut the baby's arm. The arm was cut open. After the cesarean section, the baby was taken to the neonatal division, and the woman then also had problems. So they also made a mess with the cesarean section. So 3 days later, she was taken back to the maternity ward. 3 days later, she was taken down to feed the baby. And when she got there, the baby has not been fed and the wound was not attended to. Now, that any judge will accept is glaringly negligent. So but the poor baby then suffered damages because I mean the pain, and the baby was hungry, etc. The woman suffered problems because the cesarean section did not go so well, and all of this culminated in her taking the MEC. It happened in a public hospital to court, and Judge Bertelsmann then gave judgment and said, "This is so glaringly negligent. How can you leave a newborn baby with a cut in the arm on its own? How can you not feed that baby if you know the mother has trouble? She also contracted septicemia." So in that case, Judge Bertelsmann applied res ipsa loquitur, but it is an exception. It doesn't per se say that if you find something wrong, that it was necessarily negligence. Okay, then vicarious liability. I've touched on this in the first webinar. That is where I said the MEC is responsible because the MEC is the head of the health sector in a province, and therefore she is the employer of everybody, the doctors, the physiotherapists, the nurses, every person working for the state. And because the MEC in a province is seen as the employer, when things go wrong in a public hospital, the employer is responsible for the actions. That is the principle of vicarious liability. There, I just allude you to an article that I and a surgeon have written, because what happens when you use a locum? A locum is when the doctor, for example, goes to a conference, or the doctor is busy or ill or whatever, and his practice cannot go on. And then he gets a locum. There are certain requirements for a locum. But the question is, what happens if this locum messes up? And it comes back. I remember last time in the question session, we spoke about independent contractors versus employees. Is a locum employee, or is a locum independent contractor? So if you want to, you can read that article. Now I come back to this S versus Kramer. As I said, that was a criminal case, and it was concerning a surgeon and an anaesthetist. And in that case, the court said the surgeon and the anaesthetist, they are not agents of another. They are not employed and controlled by one another. Each one performs a specific specialized function as part of a team consisting of a surgeon, an anaesthetist, and nursing staff. The one is therefore not responsible for the other's conduct in their field of expertise. I alluded to this last time, but here it comes now. South Africa does not have a doctrine, a captain of the ship. It happens in the UK, where you've got a team of doctors, then one of them will be the captain of the ship and will be in charge. That does not happen in South Africa. And remember, at a private hospital, all the doctors are independent contractors. So the one is not responsible for the other one. So if something goes wrong and you do not know exactly who to blame, then you will sue the surgeon and the anaesthetist, and for that matter, the theater team, the nurses. But we do not have one person taking charge, as they are all independent contractors. Even the operating nurse, the nursing staff in the operation room might be independent contractor and not necessarily employees of that private hospital. This makes it extremely difficult. So when the circumstances are such that you do not know who exactly is responsible, then sue all of them, and then they must come and say why they should not be held liable, but they are all independent from each other. Okay, let's think about this. I'm nearly at the end, so hang in there. We are nearly there. Let me drink some water quickly. Let's think about this. Dr. Y has been working for a partnership, first red light, of doctors for the past 2 years, length of time. Keep that in mind. He is paid per hour and they subtract pay as you earn. Once again, red light. What does this implicate now? That he is an employee. But there's no formal contract. One day, there is a misdiagnosis by Dr. Y acting in the employment of the partnership, and the patient dies. Dr. Y is held responsible, but he has no insurance. What now? Okay, so let's analyze it. He has been working for a partnership. Now, if those of you knowing the law, a partnership is not a legal person, so the partners is liable for all the debts and they share all the profits. He's been working for them for 2 years, so that is quite a long time. He cannot be a locum because a locum can only work for 6 months. He's paid per hour, so there's a pattern, and they pay as you earn. So all of that will indicate that he is an employee. It doesn't matter that there is no formal contract, because in employment law, it is not stated that contracts of employment need to be in writing. It is better to have it in writing, but it is not a legal requirement. So he makes a wrong diagnosis and the patient dies. So, of course, the patient's family or those people dependent on the patient will now sue Dr. Y. But what can he do? He can say, but I don't have insurance. So I won't be able to pay the 10 million that you are claiming. What can the patient now do? Of course, claim it from the partnership. He is an employee of the partnership, vicarious liability. The partnership becomes responsible for the action. And because it's a partnership, all the partners can then alone or as partnership be held liable for the damages that the patient suffered. And by the way, if they had Dr. Y for so long, they should have checked that he has medical insurance. So that was an oversight on their side. Okay. What are certain examples of medical negligence? A misdiagnosis. Remember, just a misdiagnosis is not per se medical negligence. It depends on whether the reasonable doctor with that specific training would have made the same misdiagnosis. And doctors are nowadays extremely scared for a misdiagnosis. And nowadays you will hear the term defensive medicine. So doctors will rather do too many tests than too little tests so that they make absolutely sure. What is a gray area nowadays is you go to a doctor who does tests, let's say x-rays, MRI, etc. And then you are referred to a a specialist, must that specialist now do all the tests over again, or should he accept the tests that comes from the GP? It's a little bit of a gray area. Most specialists will once again do all the tests, but that is where the fees become so expensive, because then your medical aid have to pay for all of that, and the following year your contribution are just increased at the medical aid. But yes, you will hear the words defensive medicine. Doctors are scared, so they will do maybe unnecessary tests to make 100% sure that they do not misdiagnose. Errors of judgment. As I've said, all errors of judgment is not necessarily medical negligence. You do the test, whether the reasonable doctor in that branch of speciality in those circumstances would have made the same error of judgment. Not getting informed consent. This is a huge problem. This is a huge, huge, huge problem. And from now on, whenever you go and see a doctor, whether it's a dentist or not, check whether they give you enough information, or do they just give you a form, or do they ask the receptionist to explain to you. That is very difficult. It is the doctor's responsibility to explain to you everything in detail. And if they don't do that and things go wrong, you can say, but I did not give informed consent. Failure to refer. There, I just want to allude again to what I said last time, that if it's against your religion or against your culture to do an abortion, you have to, in the public sector, have to refer the woman to someone who will do it. You cannot talk her out of it or make her feel guilty because you don't agree with it. You have to refer if you are not able to do it. The biggest problem of medical negligence usually is the failure to follow up. So people accept things can go wrong under an operation where people use knives, etc. So things can go wrong. But what happens afterwards? So that is a huge field of medical negligence. And then, of course, the obvious things where a wrong leg is amputated, a jaw is broken during operation, or a wrong procedure is done. Those are the obvious things. I've said a lot of medical negligence happens in gynecology. Sometimes they prescribe the wrong medicine or faulty equipment. For example, wrong medicine. What do you think? Will there be liability if a psychiatrist prescribes medicine to a patient, knowing and telling the patient that you only take this medicine if a person is near you or close to you 24 hours a day? In other words, you are under supervision. And the patient say, yes, no problem, but the psychiatrist do not check. Then the person goes home, he's alone, takes the medicine and commits suicide. Will there be liability or not? I don't know. Just think about that. Faulty equipment. Okay, radiology is where x-rays, where you could be burned. We've spoken a lot about blood transfusions, that Jehovah's Witnesses do not take blood transfusion. But remember, if it is a child and the parents are Jehovah's Witnesses and they refuse a blood transfusion for their child, then the Children's Act now makes provision that the best interest of the child trumps the religious beliefs of the parents. And then if it's a life and death case, then a blood transfusion can be done to that child, and that will absolutely be legal. Surgery and the local classicus of medical law, surgery, yes, Castell versus de Greef. Read that case, because that is the locus classicus. That is the most important case concerning informed consent. So I just allude you there. Okay, now practically, how do you handle a case? Okay. Gather all the facts. So the patient comes and see you. Now you've got two choices. You can either make notes while the patient speak, or you can make a recording, or you can send the patient home and say, go and write me down everything what happened. Focus on pre-operation. How was your health? Everything. Were you a sports person? Were you obese? Everything. And then what happened in hospital or during the operation, and what is the situation now? So you gather as much facts as possible. And as I've said, in the meantime, your head goes and check for all the requirements of a DLICT. Okay. Then I suggest, and you don't have to do this and you don't have to agree with me, but I like to ask the client, what does he or she want? Why are they here? Why did they come and see me? What do they want? Are they angry? Do they want revenge? Do they want to get closure? Do they want to get answers? Or do they want to get money to help them to better their lives? And you will see, because the reaction of the client will give you a good indication of what is it's why are they here. And remember, patients and clients remember selectively. They they will think they give you all the facts, but they remember selectively, and they might have left out a lot of facts. For, let's say, a mother dies, and now it is the husband, and he wants to sue the doctor because his wife died, and he will go on about this bad doctor that doesn't know what to do, and this bad hospital, and what, but he forgot to tell you she was completely obese and she had heart problems before the operation or whatever. Okay, but anyway, so ask your client, is it revenge? Do they want to get closure? Do they want to get answers, or do they want to claim damages, finances to help with this uncomfortable situation they are now in? Then you get the hospital reports. And once again, I go back to that book of Van der Heever and Lawrenson, because it tells you step by step how to get the hospital records. And I can tell you, hospitals are not comfortable in giving it to you. And especially in the public sector, these records disappear. But you have a right to get it. They will not give you the originals, they will give you copies, and you will have to pay for it. And please just check, as I've said last time, in a case that I'm involved, they photocopied only the top page and did not turn it over and the back. And then some things might not make sense, but you are allowed to get the hospital reports. Now you compare. You sit in your office and you look at the facts that your client told you, and you look at the hospital reports and you see whether there are links, whether you can see a picture unfolding in front of you. In the meantime, in your head, you check what law is applicable, a contract, DLICT. Will all the elements be proved, even though difficult? Does it seem provable? Okay. Now you must ask an expert. You must now take the hospital records and all the facts that your client gave to you, and you must give all of that to an expert, an independent person to look at it, and now to apply the test, to come with an opinion whether the accused doctor, specialist, surgeon, whatever, acted like a reasonable doctor of his education and skills in those circumstances, acted reasonably or not. And then when you get your expert's opinion, and the experts say this doctor did not act like the reasonable doctor, then you start building your case and you issue summons, etc., etc. Just remember that according to the new court rules is that they say that you must explore mediation before you start with litigation. Just keep that in mind. I think it's a very good thing. I think mediation is excellent in medical negligence cases because most of the time the patient just want to sit around the table with the doctor and get answers of things that went wrong and maybe just want an apology. But the doctors will not apologize because their insurance say they handle it. So the